We'll hear argument first this morning, Case 18-431, United States versus Davis. Mr. Beck.
Mr. Chief Justice, and may it please the Court. Your Honors, this case is about following the text of a statute where it leads and, when necessary, requiring Congress to speak more clearly on what is prohibited. And there are three reasons why the 924C residual clause should suffer the same fate as Section 16B. First, they contain the same language that gives rise to an ordinary case categorical approach. Second, they share a common history suggesting similar treatment under the law. And third, a conduct-based approach lies beyond the reach of constitutional avoidance. Before I move to my
those cases were concerned about the jury, protecting the right of the jury to find the facts. That concern, which undergirded all of those cases, that Sixth Amendment concern, as well as the practical concern of trying to relitigate what had happened many years ago. That is totally absent in this case, right?
Your Honor, the constitutional concern is absent in this case. Of course, there may be...
And you agree with me that that concern undergirded Taylor, it undergirded Johnson, it undergirded DiMaio.
I disagree with you that that played a central role in the decision in Taylor versus United States. Your Honor, the best evidence...
It's specifically identified in Taylor as a concern on page 601 of the opinion, where the Court talks about the abridging the right to a jury trial.
In Your Honor, my reading of that portion of Taylor is it's raising a question of judicial economy. It's within the paragraph dealing with practical and workability concerns.
Right.
And it's simply raising the question, are we now going to be faced with the problem of every defendant appealing, saying they were denied a jury trial?
And I raise this because I think the prior cases interpreted language in a way to avoid a constitutional problem, namely the Sixth Amendment problem when you're focusing on prior convictions. But that reason to stretch the language in one direction is not present here as I see it. This is the jury was all those cases were about the jury, and that the jury would be able to find the facts here.
In Your Honor, I want to be able to answer your question clearly. In Taylor, when this Court first raised the question of whether to apply a categorical approach or conduct-based approach, the very first statement was we were persuaded by all of the circuits below that reached a categorical approach. In not one of those cases is there a mention of a constitutional concern or the application of constitutional avoidance. The conclusion in Taylor was there's only one plausible...
Other interests. Why don't you list them? You talk about them generically. So what are the other interests that you think
Your Honor,
the categorical approach endorsed?
Your Honor, Taylor began with the text, then went to the history, and then noted practical and workability concerns. But Leocal versus Ashcroft in 2004 didn't discuss practical or constitutional concerns at all. It relied solely on the text when construing Section 16 and reaching the singular conclusion that that language, offense plus by its nature with the absence of conduct-specific language, requires a categorical approach.
Well, let me ask this question about the text. Let's say that a statutory provision comes before us, and it's possible to read the language of this provision in two different ways, and one may argue about which is more strongly supported by ordinary textual analysis, disregarding any practical consequences. But we know that one reading is entirely workable, and the other one is absolutely unworkable. And would we presume that would we not think that Congress is likely to have chosen the interpretation, likely to have meant the interpretation that is workable, as opposed to the one that is absolutely unworkable?
In Your Honor, I'm aware of the presumption of constitutionality, but I'm not sure.
I'm not talking about the presumption of constitutionality. I'm talking about the presumption of rationality.
I think that's relevant when construing a statute. I would agree with you on that. The question here ultimately...
So if the language can be read in the workable way, as opposed to the way that's completely unworkable, we would choose the way that's workable. We would think that's what Congress meant, not something that was dead on arrival.
Your Honor, we must begin with the text when trying to determine what Congress meant. Workability has to be a secondary or tertiary consideration. Here, the government has proposed a new reading, a conduct-based approach that cannot be reached by constitutional avoidance simply because it's not a plausible
Well, let me
reading.
ask you this textual question then. And look, this is looking at subsection capital B. When, under your understanding of the categorical approach, when the court is determining whether an offense by its nature involves the requisite risk, is it not asking, do the elements in themselves involve that risk? Isn't that what it boils down to?
I disagree under this language, Your Honor.
So what does the court look to besides the elements to determine what is the typical case?
Well, as this language has been construed, this court would imagine the crime's imagined ordinary case. And we get there from this court's opinion in James versus United States, noting the dual, inherently probabilistic language that's present here.
Yeah, okay. Let's take burglary, the classical definition, unlawful entry of a dwelling with the intent to commit a felony. So now I want to think of the ordinary case of burglary, and that's what I think of. What do I think of beyond that?
You think of how burglary is often or ordinarily or typically committed, and you then ask the question, what is the risk associated with that? Now,
Okay,
that's if
so
it's
what,
constitutional.
What is typically done in a burglary beyond the elements of burglary?
The problem with this is we can't answer that question. Justice Scalia explained, for example, with possession of a short-barreled shotgun in Johnson, is many times as we try, even with these common offenses, ultimately it becomes an impossible question.
Why is it impossible?
I understand that, but if I could just – I'm sorry, Steve. Justice Breyer, go ahead, please. If you can't tell me what beyond the elements of burglary one would take into account under B in determining the typical burglary, I think that what we're talking about there, under your categorical approach, is the risk that's inherent in the elements of burglary. And if that's the case, why is there no reference to elements in B when there is a reference to elements in A? Doesn't that tell you we want to look at something other than merely the elements of the offense?
I would agree, Your Honor, but not conduct. Here, and this kind of goes back to Justice Gorsuch's question to the government. How do we construe this when the word offense is the subject phrase for both subsection A and subsection B? This Court answered that question in Clark v. Martinez, that words cannot be treated as a chameleon, meaning one thing for one purpose and another for another
I
subsection.
understand that. I have a different question, which perhaps is puzzling only me. But both you and the government assume that without this case-specific interpretation, the statute would be unconstitutional. Why? But let me tell you why not, and then you tell me why I'm wrong. What we had in Johnson was a statute that said, in defining the relevant crime, burglary, which is sometimes violence, arson, probably a lot of violence, extortion, hardly ever violent, explosives, often violent, or otherwise involves conduct that presents a serious risk, potential risk of physical injury. And it's that last phrase that the Court, sort of with Justice Scalia writings, threw up their hands. In that context. And both Judge Posner, in a lower court opinion, and I think I've said the same thing, there's no problem here. Let the government go look at the pre-sentence reports and let them discover how often these crimes do involve violence, and then categorize. Now, that's very tough to do with the Johnson case, because with the Johnson case, you're talking about state crimes that are phrased in 4,000 different ways. But it's sure not tough to do here. This is a federal crime-based statute. The government has all the pre-sentence reports it wants, and it could go through and categorize which are violent and which crimes are not. And if that's so, I don't see why it couldn't. If that's so, this would not be a difficult statute to interpret. It would not be very ambiguous. And therefore, you win, but you lose, because, in fact, it isn't unconstitutional. Now, if I think that, which I do, is there some is there some killing argument against it, which there may well be, which should tell me I'm really either alone or out of my mind or et cetera? You understand?
I understand, Your Honor. One of the reasons we have the void for vagueness doctrine is to support the separation of powers by not delegating to judges and prosecutors the authority to define the contours of a criminal statute, particularly a criminal statute that takes sentencing discretion away from judges and imposes harsh mandatory minimums, in this case 25 years. But I want to tell you —
Keep going.
I want to tell you why this is like Johnson. And, of course, we shouldn't forget about Sessions versus DiMaia, which looked at the same language. The same two features in Johnson that conspired to render the residual clause void for vagueness are also present here. First, a lack of guidance on how to imagine the crime's ordinary case, coupled with an indeterminate risk threshold. And stare decisis finds its greatest strength in questions of statutory interpretation.
Let me just follow up for a second, because the words are substantial risk, okay? Substantial risk of physical force. So what the court writes, I'm not saying we should, is in Clause A, it's an offense, it is a felony, has an element, the use, attempted use, or threatened use of physical force, right? So we get the pre-sentence reports. And we see what the average risk of those crimes is in terms of physical force. And then we say B means the same. Those crimes that have the same risk of physical force in respect to B as the crimes in respect to A are what this language is referring to. That would be clear. Nobody's tried that. I've suggested it. So what do? I guess you would like me just to say the government's conceded it's unconstitutional. That's the end of it.
Well, and to address your proposed solution, Your Honor, at that point we'd be delegating to United States probation the authority to define this. Well, we're looking who writes the pre-sentence reports? U.S. probation.
They write the pre-sentence reports according to the facts, and anybody who wants a trial as to any fact in respect to a pre-sentence report and have a jury to find it, or the judge, if it's inappropriate, can do it.
And then we run into the same problem in Johnson and DiMaia. What statistics do we use? What other sources do we use? And this Court has never been able to answer that question, and I think appropriately, because it's an unanswerable question.
But in Johnson, we said we distinguished cases about prior convictions where you're looking at risk from this case and said, more importantly, almost all of the cited laws require gauging the riskiness of conduct in which an individual defendant engages on a particular occasion. So that was to say, and then went on to say, as a general matter, we do not doubt the constitutionality of those laws. So why would a law that refers to substantial risk be unconstitutional when the Court in Johnson said that's not an issue?
Well, it's certainly not always the case, Your Honor.
But it's usually the case. The Court said, do not doubt the constitutionality of all those laws.
Oh, no, I would agree with you that most of the time a jury is capable of making a risk assessment. The question here is not whether the jury is capable of doing, but if that's what Congress intended.
Right. I take your point on that. On your vagueness point, vagueness is born in a conception of fair notice. You would agree with that? Right?
A combination of fair notice and the support of separation of powers, Your Honor.
And hasn't Congress in 1986 was concerned about the enormous problem of gun violence, of violent crimes committed with guns, which was bad as it is now, extremely bad, worse, much worse in the 1980s.
No question.
And put everyone on notice, fair notice. If you commit a crime with a gun, you were going away for a long time. That was Congress's obvious intent, overwhelming intent because of the problem. And the idea that I mean, I guess I'm not seeing the notice problem, given that that has been crystal clear since 1986 for everyone in this country.
Well, if that's what the statute said, I would certainly agree with you, Your Honor. But if we look to how Congress was thinking about these things when it passed the Comprehensive Crime Control Act in 1984, which created the Armed Career Criminal Act, Section 16, as well as the first definition of crime of violence here, Congress was thinking about the predicate offenses categorically as categories of traditionally violent crimes.
Well, on the question of what Congress was thinking, maybe we could just take a glimpse at what actually happened in this case, which is that the defendant conspired to commit and then committed a series of robberies of convenience stores where they put a sawed-off shotgun to the head of a clerk and then robbed cigarettes. Now, you really think Congress would say, well, that's not really a crime of violence?
The defendants in this case are guilty of every offense you just described, and we're not challenging any of those convictions. The difference here today, if we were to win and remove one of the 6 counts that they were convicted under, is that either they would die in prison or be released as very old men.
But that's not my question. If Congress had in mind this kind of crime, do you think Congress would say, no, that's not a crime of violence?
As to the robbery, certainly I would agree with you.
As to the conspiracy. They would say that's not a crime of violence?
Congress has not spoken clearly on that question, not with the language it chose.
Do you have any doubt what they would say?
I certainly do have doubt about whether Congress intended to include conspiracy when it was thinking about traditionally violent crimes, simply because conspiracy is an inchoate offense.
Counsel, looking at what Congress actually wrote in terms of canons of construction, we sometimes consult. One we've heard about so far and talked a little bit about is the canon of constitutional avoidance. This Court will attempt, when possible, sometimes to avoid a construction that renders Congress's work null.
Yes.
We also have, though, the canon of construction, the rule of lenity, that we don't typically construe statutes to be as grievous as they could possibly be read. And for the notice problems that you've talked about and the separation of powers problems, if Congress wants to act more grievously, it needs to speak more clearly before it deprives a person of his liberty. Usually those two canons point in the same direction. This is an unusual case where they point in opposite directions. Have you done any study or examined how historically those two canons, when they compete, are reconciled?
It's a difficult question to answer, Your Honor. We know, for example, from Clark versus Martinez that we resolve all textual canons before reaching avoidance. Dealing with another normative canon like lenity, it's not clear. I couldn't cite a case, for example. It certainly makes sense that constitutional avoidance —
Well, before we get to what makes sense, we hear a lot about what makes sense in this room. I'm curious about what the law is. Okay. Have you done any examining of historical sources? I don't know, Joseph Story, pretty good source on commentaries of the Constitution, or Blackstone, something you can point me to in this law about how those two get reconciled. And if the answer is no, that's a perfectly fine answer. I'll go look myself. I just thought you might save me a little time.
I'd like to start with no, but I would like to take another attempt at answering your question. The rule of lenity serves multiple purposes.
All right. Now, go on to another question. You'll do better work elsewhere. I thought we
had said the rule of lenity only kicks in after you've done all the other tools of statutory interpretation, which would include constitutional avoidance.
And, Your Honor, that
we've said that many times.
I've read it inconsistently in application there. Certainly they exist in the same sphere. They're both triggered by concern over ambiguity. They both are used with a plausibility standard. But the reason the government's proposed conduct-based approach is not plausible really comes down to the rule of lenity. But in addition to that, and perhaps more importantly, it's irreconcilable with the plain text of the statute. It conflicts with how this Court has already interpreted identical language, and it offends the separation of powers.
Well, could I come back to the question about the meaning of the word offense? which you addressed, which Mr. Fagan addressed extensively earlier, does that same problem exist under ACCA? And if it doesn't, are you saying
certainly.
It does? The problem exists under ACCA?
The problem in the sense of the crime has to mean the same thing for purposes of both subsections because it has the same subject. And that's consistent with our argument. The government, in fact, is trying to change that. So the government, for example —
let me ask it a different way. Do you think that the residual clause in ACCA can be objected to on the same ground that you are using to object to the use of the case-specific approach, the fact-specific approach to the residual clause here?
I think so, Your Honor, absolutely.
Well, could you just explain how that is?
Sure. And if I can refer to precedent while doing so, but I'll do it without mentioning Taylor, for example.
Well, I thought I'd prefer if you can do it with the language. If you don't have the language in mind, then I'll just leave it.
I have the language. The same problem exists in both. The lack of guidance on imagining the ordinary case of the crime in the indeterminate risk threshold, those are present here as well as there. You also have the dual inherent probabilistic language that gives rise to the ordinary
what I'm
case.
getting at is this, your argument that the provision here under the government's reading interprets the word offense to mean two different things, element at one point and facts at the other. The way ACCA is worded, that problem doesn't arise. It talks about a crime, and then in subsection I has as an element, subsection 2 presents a serious potential risk. So you don't have that problem there, do you?
We do have the same problem because what's modifying crime is not presents but involves conduct. So it's a parallel reading here. And, of course, if we look to Sessions versus DiMaia, it's the same language. But going back to 19 —
So you don't think there's an important distinction in this respect between the language of this provision and the provision of ACCA?
Certainly not, Your Honor. And I think the plurality of this Court answered that question in Sessions versus DiMaia just last term.
So if I don't think that there is that problem under ACCA, then I shouldn't think there is that problem under this provision?
I would agree with that, Your Honor.
Good.
If we go back to 1984, when Congress created both Section 16 and for the first time narrowed the application of 924C from all felonies to just crimes of violence, they were conjoined with a cross-reference. At that time, even if we didn't know what Section 16 and Section 924C meant, we know Congress intended them to mean the same thing.
They changed it in 86. They changed the cross-reference.
They removed the cross-reference, but what they did —
Doesn't that defeat your whole point there?
It does not, Your Honor, because they used the same language. So the truth is neither the government nor respondents know exactly why Congress chose to copy and paste the language from Section 16 into 924C, but we know they used the same language. So it makes better sense that they were doing so for convenience, because it was at that time that they were also adding a definition of drug trafficking crime. In Rassam versus United States, I believe in 2007, this Court dealt with a similar situation where two provisions used the same language at inception. And the way Congress intended a different meaning there is it changed the language in one but kept the language in the other the same. Yet here we're faced with 30 years of a categorical interpretation from circuit courts. We have 3 different instances where Congress has changed the language of 924C in that time, and not once has it changed the language that gives rise to this categorical approach. So I think that gives us some insight into congressional intent through this amendment history. Just last term, this Court stated in Jennings versus Rodriguez, quote, "Spotting a constitutional issue does not give the Court the authority to rewrite the text of a statute. In the government's proposed conduct-based approach would effectively be asking this Court to do just that." One of the big limitations on the application of constitutional avoidance is the separation of powers. Congress alone is the lawmaking authority. and a conduct-based approach would offend that in the truest sense.
So the basic question we're asked is the question of whether it's too vague. That's why I'm in my dilemma. And certainly the conduct-based approach is one effort to escape. All right?
That's correct, Your Honor.
Well, so what do I do if I think, you see these words here, a substantial risk that physical force against the person? What they mean is the same risk of physical force as in A. And therefore it isn't vague. Maybe there's some obvious answer to this, but it's gnawing at me. And
yeah.
See, if you were to do that, it would be very specific, and it wouldn't really be like Johnson, because Johnson put a lot of weight on the fact that they have 3 examples which cut in 4 examples cutting in different directions, and they're state crimes. And suppose I just wrote that and said that hasn't been argued.
Here's the
so
difference.
What would you do if you were, unless you see some obvious problem?
Here's the difference. Subsection A is asking the question, does it have an element of force? Mm-hmm. Subsection B is asking a different question. What is the risk of force posed by the nature of the offense? Mm-hmm. Those are 2 very different questions, although I would agree with you that subsection B sweeps more broadly.
Maybe that's right.
Yeah.
I'll think about it. Thank you.
I'd like to address the government's use of Najawan and Hayes. In Najawan and Hayes, this court did identify a statute that is a hybrid statute that involves both a categorical inquiry as well as a fact-based inquiry. But what was present there is a clear indication from Congress that we were to look at fact-specific conduct, using the language in which or using the language committed by. And it's important to note that one of the reasons this court ruled the way it did in Najawan is because the provision right above it clearly called for a conduct-based approach, and it had identical structure. If we were to apply that same reasoning to this case, it would require a categorical approach, because drug trafficking crime is categorical, conceded by the government. The elements clause is categorical, effectively conceded by the government. And why would Congress intend to treat subsection B any differently without clear intent based on the language it chose? 2 other provisions that are also categorical in nature that apply to present offenses that are cited by the government, Section 929 and Section 931, one dealing with body armor in connection with a crime of violence, one dealing with the use of armor-piercing bullets. If the government is correct here today, those would be treated differently than 924C, use of a gun. And I think that really calls into question the internal coherence of the body of law. I think this court does have some obligation to seek a harmonious interpretation of the body of law, and many of the points raised by the government today would destroy not only the internal coherence of 924C, but also its external coherence with the way this court has interpreted Section 16. And so it's for these reasons that we ask this court to affirm the judgment of the Court of Appeals for the Fifth Circuit and hold the 924C residual clause void for vagueness. Thank you very much.
Thank you, counsel.